So I want to answer this question that was posed in one of my previous videos. Does a 21-year-old need a will? Absolutely. Let's talk about it. Hi everyone, my name's Leah Boston. I'm an estate planning attorney here in the state of Maryland and owner of Law Office of Leah Boston, LLC. I draft wills, trusts, and I talk about long-term life care planning with people like you. So, does a 21-year-old need a will? Absolutely. So let's talk about the rules first and foremost. In order to draft a legally valid estate plan, you need to be of the age of majority. And usually that's 18 for most states. Here in the state of Maryland, to draft a legally valid will or a trust, you need to be at least 18 years old and of sound mind, which means you're like mentally competent, you're understanding of what you're doing, why you're doing it, the importance of the documents that you're signing, and the people who you're basically giving your stuff to, essentially like understanding the nature of your bounty and the people that you know are either your heirs, beneficiaries, etc. So it's really important because although 21-year-olds are kind of really just starting in life, whether they're starting their careers, coming out of college, etc., they may feel that there's no need to have an estate plan in place because they don't feel like they have enough of an estate to start the process. However, this is so wrong because estate planning is not necessarily about what you have and who you're going to give it to, but it's also what happens in the event that you're unable to speak for yourself, or if you're not in the position to speak for yourself due to being just absent. As an example, if you're traveling out of the country and say, for example, you are buying a house and you're not able to actually meet with the lawyers or the real estate brokers, etc., to contract on that house. If you have a financial power of attorney put in place, or just a power of attorney put in place, that individual can contract on your behalf and kind of be your voice for you. So this is a good reason why you kind of want to have an estate plan in place, because not only will it say where things go at death, but also you can kind of put in place in parameters people that can operate and keep your life going if you can't. A good reason to have not only a will, but just an entire estate plan in place is if something were to happen to you and you go to the hospital and you're unable to communicate with the doctors. Or if you need your parents to have access to your medical records to pick up medicine for you, etc. We have things that are called HIPAA authorization waivers. And with those, we essentially are allowing people that are not necessarily on our medical records to be on our medical records, to essentially say, hey, I'm calling to get information about patient X. Can you tell me the status, the prognosis, what's going on, what room they're in, and why they're in the hospital, etc. Because of HIPAA laws, legally, nursing staff, healthcare professionals are really not supposed to give your medical information to people, even if they're your family, because if you are over the age of 18, you are legally an independent adult. So when you have an estate plan in place, not only a will, but an entire comprehensive package, you are putting parameters in place for a financial power of attorney. You're putting parameters in place for your loved ones to be able to call the hospital and kind of demand answers about what's going on with you. And you can also put something in place here in Maryland. It's called an advanced medical directive, and that advanced medical directive is kind of like a healthcare power of attorney. So if you're unable to communicate with the doctors what you would want to happen in the event that something happens to you, and either you are comatose or worse, like obviously I don't want to be a Debbie Downer in this video, but it's just like life happens and things happen, especially as young adults. Our behaviors are unpredictable. I know when I was 21, my behavior was probably more unpredictable than it is now at the age I'm at now. But I say all that to say, when we're thinking about estate planning, yes, 100% you need to put a will in place, because whether you own a car or you have furniture belongings, a pet possibly, we need to know, or the courts need to know, what's going to happen to all of that stuff in the event that you pass away. More importantly, if you are still walking on this earth and there, for whatever reason, you are unable to communicate your demands, your requests to either doctors or other financial professionals because of temporary absence or absence due to traveling overseas and things like that, you have a comprehensive package that is allowing legally that this person can speak on your behalf. I know I kind of just like brought it all around town, and I know you specifically just asked about a will, but it is more than just a will. So the long answer after the, what is it called? Long story short, or short story, but I'm gonna give you the long version. Yes, 21-year-olds and older, or in actuality, if you are 18 years of age and older, you need a will, and not just a will, an entire comprehensive estate planning package that consists of the documents that I talked about today. I hope this helps. If you have any more questions, please leave comments. But other than that, I'll see you in the next video. Bye.